I'm Kate Covey. I'm going to cover the first part of the presentation, and my colleague Tito Medina is going to cover the second part. We're both equal opportunity specialists with the compliance branch of the U.S. Department of Housing and Urban Development's Office of Fair Housing and Equal Opportunity. So part of HUD FHEO, if you don't want to say the whole mouthful. In the compliance branch, we handle both Title VIII Fair Housing investigations, which we're going to speak with you about today, the Federal Fair Housing Act. And we also handle civil rights related program requirements for HUD grantees. We monitor those entities that receive HUD funds. And so the Federal Fair Housing Act turned 50 years old in 2018. So it's not a new law. It originated in 1968. It was amended in 1988 to add additional protected classes of disability and sex. And we'll talk about, the different protected classes in the next slide. But kind of some context of why and when the Federal Fair Housing Act was passed in 1968. The country had been talking about the need for a housing act to protect discrimination in housing for a while, and it just hadn't come to fruition. And then Martin Luther King Jr. was assassinated, and the country erupted in riots. And when that happened, the US government started the Kerner Commission. And the point of the Kerner Commission was to kind of study the racial and civil unrest in the United States and ask why? Why is this happening? And what the Kerner Commission found, one of the main findings, is that we are living in two societies, separate and unequal. And it was that racial inequality that was the source of the social unrest. And it was Martin Luther King Jr.'s assassination that really spurred the passage of the Federal Fair Housing Act in 1968 to work to create change for the discrimination we were seeing then. And you'll often hear fair housing folks say that discrimination has changed since the passage of the 1968 Fair Housing Act. When the Fair Housing Act was passed back then, over 50 years ago, you would see really overt in your face discrimination. You would see written ads that say, blacks need not apply, no Jews, things of that nature. And now what people kind of say is it might be discrimination with a smile. It's much less overt, but it's still happening. We're still receiving and investigating complaints. I'm sorry. So if you guys have any questions during the course of our presentation, feel free to unmute yourselves and jump in. I know you can ask it also via the chat, which I might miss, but we'll make sure to get to your question if you ask it on the chat. The Fair Housing Act covers 7 what we call protected classes. These are the groups that are protected from discrimination under the Federal Fair Housing Act. So the classes covered are race, color, national origin, sex, familial status, disability, and religion. And I think a lot of them are self-explanatory, but I want to say a note: familial status is the presence of children under the age of 18 in the household, so a family with children. And it also covers pregnant women. And then color is something that we might not talk about a lot directly related to discrimination. A lot of times we talk about race or national origin instead. But colorism, the preference for lighter skinned folks, is something very real in our culture and society, and other cultures and societies that are covered by the Fair Housing Act. So in Puerto Rico, it is much more common to see overt color lighter skinned folks. So in Puerto Rican communities, that's a protected class basis we might see more frequently. So now I'm going to go over the portions of the act and what the Fair Housing Act prohibits. The first part of the act, 3604A or 804A, it's sometimes listed different ways, prohibits discrimination in the sale or rental of a dwelling. So you can't refuse to sell or rent a dwelling on one of those protected bases. Those overt things that I was saying before, either overt or unovert, you can't do that. You can't refuse to negotiate. So you can't even say, I won't even talk to you. There's this catch-all language that's in the Fair Housing Act that says, you know, you can't refuse to rent or sell or negotiate or otherwise make unavailable. And it's kind of a catch-all. There's a lot of ways you might otherwise make something unavailable. So those are pretty basic and easy to understand. And so this is interspersed with some pop quizzes. So feel free to unmute yourself if you want to jump in and participate. Otherwise, I'll talk through it. So the first one is, a manager tells a white renter that 3 one-bedroom units will be available on March 1st. 15 minutes later, the same manager tells a black renter about 1 unit being available on April 1st. True or false? Would this be a violation of the Fair Housing Act? Does anyone have any thoughts there? Okay, so when I look at this, I say, I have some concerns that in 15 minutes, 3 bedrooms got rented. So HUD would definitely take a fair housing complaint with someone calling about this concern, right? But then, you know, kind of the lawyerly response would be, well, it depends. We need more facts, right? So HUD would take this complaint for it to be investigated. And when HUD gets a complaint, we're neutral, unbiased fact finders. We don't have a decision made. We're required by law when we get a complaint to investigate it. And so we interview parties and collect various documentation to investigate that. So if I got this complaint assigned to me, I would say, I can't tell yet if discrimination occurs. It, you know, looks a little fishy on the surface, but I need more information. I might, you know, in my interview ask the housing provider, well, did you get any calls in those 15 minutes? Did you have applications submitted? How did those units become unavailable in that time? And it could be very real situation that those units were rented and discrimination did not occur. But we would be concerned about race-based discrimination in 15 minutes that a black renter was told about less units. So that might be refusing to sell or rent specific units, making housing unavailable. But moving on, so the next portion of the act is 3604B or 804B. So the first part was about just flat out refusing to rent or negotiate. This is about providing different terms and conditions. Discrimination in the provision of services or the facilities connected therein. So basically applying the rules differently to different people. Here's an example, prioritizing repair requests for male tenants while neglecting female tenants. I've actually had a case in the reverse where a male tenant was alleging that maintenance expected him to perform his own repairs because he was a man, whereas they helped women more. So that different in terms and conditions related to repairs is something we'd be concerned about under the Fair Housing Act. Another example is steering families and singles to different buildings. This is actually something we see a lot. And so what steering means, it would be, you know, well, we place our families in this building to keep the noise down in other buildings. Or, you know, we tend to put families with children on first floor units. So, you know, our first floor tenants don't hear the pitter patter of feet on the second floor. And while it may sound well-intentioned that you're trying to keep all your residents happy, it is in fact discrimination and segregation. And kind of a gut check you all can do is, well, let's replace the protected class of familial status with another protected class. If we would say, you know, well, we tend to put all the Christians in this building and all the Muslims in this building, that doesn't sound right, you know, or we tend to put all the Americans in this building and the Chinese in this building, you know, that's the type of steering, different terms and conditions. This building is for one people, that building's for another. Different provision of services that is illegal under the Fair Housing Act. So another pop quiz. So a property management company posts a rule that nobody under the age of 18 can use the pool without the presence of an adult. So does anyone want to jump in and say if you think this would violate the Fair Housing Act? Okay, so this is a rule that's being applied to families with children that's not being applied to families without children. So a blanket rule that children under the age of 18 can't use the pool without the presence of an adult is a violation of the act. Some people have a hard time with this. So if there's a legitimate business reason, you know, the business would say, well, what about the safety of the child? But 18 is kind of an arbitrary age because there could be a 30-year-old that can't swim and there could be a 10-year-old that can swim. And courts have held that different provision of services and facilities related to the pool, such as outright like adult-only swim times, violate the Fair Housing Act. What if the age was 16? That goes kind of to the arbitrary nature again. Courts have said, you know, there could be a 16-year-old certified lifeguard that does the lifeguard duties, you know, during the summer, and they could be a fine, perfect, safe swimmer compared to someone of a different age. And I told you the answer to the third one. Adult swim time has been found by the courts to violate the Federal Fair Housing Act. There was an interesting case recently about pools. It was in a Hasidic Jewish community, and they had separate swim times for men versus women according to their religious rules. And that would probably all be good and fine, but those swim times provided to women, the provision of those services provided to women were at much less convenient times than were for men. And it was under the argument of, well, the men are working and the women aren't. So the men need the times that are like convenient for their schedules. Well, that wasn't true for all women, and the courts held that those rules violated the Fair Housing Act on the basis of sex. So pools are kind of tricky, but you just got to remember, if you have a legitimate business necessity, that could be a reason, but it has to be the least discriminatory method possible to reach that legitimate business necessity. Okay, so Section 804C of the Fair Housing Act covers discriminatory statements. The Federal Fair Housing Act prohibits housing providers to make, print, or publish, or cause to be made, printed, or published any notice, statement, or advertisement that indicates a preference, limitation, or discrimination.
Hey, Kate?
Yeah.
Somebody asked a question about the previous slide. They were asking, what about like in pool insurance? What if the insurance company has you put up a sign or have rules in effect that say that, you know, no children under 18 can be present without the presence of parents?
Thank you, Tito, for grabbing that question for me. I would say that's probably something you would want to bring your lawyer into to discuss with your insurance provider. You should be hesitant to apply those rules that I'm telling, or those policies that I'm telling you violate the Federal Fair Housing Act. The insurance provider might not understand the Federal Fair Housing Act. And so I would just consult your attorney there on what you should do, because in that instance, it actually might be the insurance provider that has a fair housing case put against them, as well as you. I don't know, you know, where the line of responsibility would be drawn if your insurance provider is telling you to implement those rules. But I think as the housing provider, you would also still be liable You know, so you'd want to get a lawyer in there to help you navigate that situation, I would say.
I agree as well.
So thanks for that question. And thanks, Tito, for monitoring the chat for me. So here are some pop quiz examples about discriminatory statements and advertising. Again, feel free to jump in if you want, or I'll just brainstorm about the examples. But what do you guys think? Does mature persons violate the act?
Yes.
Yeah, so again, I'll be lawyerly and say it depends. I would definitely have some concerns that mature persons would be discriminatory against families with children. You see that a lot too. Like a lot of times nowadays, you'll see an advertisement that says perfect for a single person or a couple or something, and you know, but they're intentionally omitting families with children. So we might be concerned here. Age is not a protected class under the Fair Housing Act, but you know, as we've been going over, familial statuses. So we probably, for HUD to charge a case to say, yes, discrimination occurred, we might need a little bit more. We might need, you know, an actual person, right, that applied and was turned away because they had children. But this would be a trigger that we'd say, is there something going on here? What about ideal bachelor pad? Would that language in advertising violate the Fair Housing Act?
I could see how it can.
Yeah, I would say, again, this depends. So we know that traditionally a bachelor pad refers to a male. So this could be some sort of sex discrimination. And so again, I might have some concern, but I think we need a little bit more information to see, are females or families, you know, a bachelor often is someone without children. So are females or families actually being turned away from this housing? What about, does no pets violate the act?
No, not necessarily.
Right.
Yeah, so you are perfectly allowed to have a no pet policy. And Tito's going to cover some of the disability protections later in the PowerPoint. But what I just want to point out to you that is that any type of assistance animal is not considered a pet. And so those pet policies cannot be applied to an assistance animal. So it can't be applied to a service animal, an emotional support animal, or a companion animal, all which fall under the branch of assistance animal. So you're perfectly fine to say no pets. And if it's actually a pet, go ahead. But if it's assistance animal that provides assistance to a person with a disability, those pet rules cannot be applied. What about, does one person apartment violate the act?
Oh, no, I don't
Yes.
know.
So this is tricky. I wouldn't say just on its face it does, because there are some zoning codes that the house might be too small for more than one person. However, I would like to point out to you that HUD has a standard that I think they set back in the 90s. We call it the Keating Memo. And what the standard HUD has said that they have established and you know, courts have upheld is a standard of 2 persons per bedroom. So that's what they say is reasonable, is if it's a 1-bedroom apartment, you should be allowed to have 2 people there. And then there are some other things it talks about to consider. You know, if it's a large place, might they use a living room as another bedroom? So even if, you know, it's a mother and a partner and a child, and it's only a 1-bedroom, maybe there's actually enough square footage for it to be okay for 3 people. So you just want to keep in mind that there are local laws that regulate square footage and occupancy that you should, of course, comply with. And again, if those were overly restrictive, the fair housing complaint would be filed against the locality with those overly restrictive ordinances. You know, you have to go along with whatever local rules, right? But I think it's important to keep in mind the general standard is 2 persons per bedroom, and maybe even more flexibility. It doesn't have to be a bedroom. It might be another room used as a bedroom if there's enough square footage. Okay, So an advertisement describes a property as seniors only. Would this violate the act? I think you all are pretty aware and probably work with some senior housing, likely. So there are provisions to allow for elderly housing or near elderly housing. And some of the numbers in the coming up questions kind of give you a clue. Elderly is typically 62 and over, and the near elderly is 55 and over. And if you're going to operate elderly housing, you just have to make sure you're meeting those strict requirements of renting to those age groups. Because I think there's a certain threshold, you guys might know better than me, it's a percentage, like this many people need to meet that age requirement. And if you don't do that, then you might be violating the act because you're turning away some families with children and maybe not others. So you just got to make sure you're following all the rules for the elderly housing. And again, remember I said age isn't a protected class, but familial status is. And so if an elderly person had custody over a younger person, that's something that should be considered, and the protections under the Fair Housing Act should be considered in that situation. Okay, so 3604D is to represent that any dwelling is not available for inspection, sale, or rental when it is in fact available. So this is misrepresentation of availability. What we might see here is if discrimination were occurring, a housing provider has advertised a unit and they're getting calls about it, and they tell those people with accents that they think are of a different national origin that the housing is not available when in fact it is. So those are the things we're talking about here. So true or false? A leasing agent tells a male renter with a child about 2 ground floor units available for rent. The same leasing agent later tells a female renter with no children about units available on the 2nd and 3rd floors. Would this violate the Federal Fair Housing Act?
Yes.
Yes.
Yes, that's correct. So I talked about this example earlier. This would be segregating families with children to 1st floor units. You know, we might have some questions, right? We might want some more facts. Like I said, the lawyerly response, it depends. You know, we might say, how much later did this, leasing agent tell the female renter with no children? Was it a few days? Might of some existing residents put in their notice and those units did in fact become available? Might an application have fallen through that those units were claimed for and it came back on the market? We don't know. But we would be concerned with this fact pattern and we'd investigate it. Okay, I think this is the last one before I turn it over to Tito, but the PowerPoint will let me know for sure. 3604E is about block busting. So the Fair Housing Act makes it illegal for profit to induce or attempt to induce any person to sell because of a protected class group moving into the area. And so this was much more common in the 60s. In a time when we were having white flight from the cities to the suburbs, and we were having more integration and Black people moving into predominantly white neighborhoods. And what would happen is that real estate agents would go around to the white neighbors and they'd say either, oh, I heard that house down the street sold to a Black couple. You better get out while the getting is good because housing prices are just going to drop and the neighborhood is just going to go down the hill. And then they scare the white people into selling the house for cheap and then turn around and sell it to someone else for more expensive to make money. So it was a fear tactic that they were using to scare white people into selling their houses and making money off of it. And so while it was a more historical thing, we do see a lot of what we call NIMBYism, not in my backyard, related to, for example, affordable housing. So there might be some cases that we see where someone says, oh, there's an affordable housing or a public housing complex being built down the street. You better get out while the getting's good. And, that's illegal and that's protected by the Fair Housing Act. And so with that, I'm going to turn it over to Tito. He's going to cover the disability protections under the Fair Housing Act. And in passing it over to him, I'll say one thing I say about disability protections is with the Fair Housing Act, we're always saying, you know, treat everyone the same, apply the rules to the same to everyone, don't do different terms and conditions, don't have different eligibility criteria, rent the same to everyone. But persons with disabilities are a protected class group that sometimes you need to treat differently if they ask to give them equal opportunity to enjoy the dwelling. And Tito's going to jump into that in detail.
Okay, thank you, Kate.
And I'll let you get the PowerPoint up so you can advance your slides. And I'll monitor the questions for you.
Okay, do you see my screen?
Yes, but you have to start it from the beginning so we see the whole PowerPoint, or start from current slide. Yeah, perfect. Right?
Cool. Okay, everybody. As Kate was saying, my name's Tito Medina. I am a federal investigative agent out of the Office of Fair Housing Equal Opportunity. And we are in charge of ultimately administering the Fair Housing Act and the ADA when it comes to housing situations in America. Right now, we're up to the portion where they specifically start explaining how you cannot discriminate against disabled persons. So this is 3604 F1. It is illegal to discriminate in the sale or rental, or otherwise make unavailable or deny a person a rental, or even a rental due to their disability, due to a member of their family's household disability, or any other person associated with them. I know I've investigated several cases where the mother is the disabled person, but it would be like the daughter is the one that was having issues with a landlord or something, and it was strangely related in that way. So it doesn't have to necessarily just be the disabled person. It could be your associations with that disabled person. The example they have here is housing authority director refused to lease a disabled tenant because she was concerned for his safety. What that pretty much means is like, hey, we didn't want to rent out to this person for a second floor apartment because we noticed, he was using crutches or he was on canes or something like that. And ultimately, it really is for the person applying to make that decision, not for anyone else. There's no questions. Moving on to the next slide. Okay, 3604 F2. Discrimination in the terms, conditions, or privileges of sale or rental. We get a lot of complaints when it comes to someone was treated differently, let's say for maintenance. They believe that their maintenance takes longer than someone else's. Or let's say someone added an additional provision for an additional security deposit because this person's in a wheelchair. And something to that effect. Like we do see generally a lot of our complaints that end up under this title, 3604 F2. The example that they give here is a disabled renter is unable to get into the office because the doors are too heavy to open and the leasing office ignores the repair request to fix the automatic doors. I could see a complaint like this actually come up under this particular violation and under another violation that deals with reasonable accommodation requests or even possibly a reasonable modification request, depending on the funding that the property owner gets. Next slide. Okay. 3604 F3 Alpha, refusal to grant or request a request for reasonable modification Such a modification may be necessary to afford a person an equal opportunity to use and enjoy the dwelling. So, you know, you're in a wheelchair now. And let's say you so happen to live in a property that gets federal funding. And you're in a wheelchair and they can't move you to another unit because they don't have any other units. Well, how are you going to get in and out of your unit if that doorway isn't wide enough? If you're in a situation where they're federally funded, they would have to widen the door. But if you were in a regular housing situation where there's no federal funding, right, a request like that, that type of reasonable modification may have to be, the cost of it may have to be incurred by the person asking it. And what generally our office looks at is when you made the request, did you have capital to be able to actually, you know, get the request, carry out the request? Because in some cases, somebody may make a request, like let's say, you know, I live on the second floor and I want to put in an elevator. And I ask the owner to put in an elevator. And they tell me, no, I can't do that. So they make a complaint with us. But ultimately, the person making the request could not have actually constructed an elevator to be made at the property. So we would have to look at the complaint in that nature. But reasonable modification request complaints, we get a lot of these. We get a lot of them. I actually just finished one that dealt with automatic doors. It was a senior place. They did not have automatic doors initially in there. And one of their elders that lived on the first floor ended up in a wheelchair and she needed automatic doors and they're putting in those automatic doors. Does anyone have any questions so far? Hearing none, I shall move to the next one. Okay, so here's some more examples of the types of modifications I was talking about. The widening of doors, that'd be for the wheelchair persons, installing grab bars. That could be going up the stairs. Like let's say you live in some type of townhome that has a 2-story structure. Let's say you need a grab bar in the bathroom to stand up or sit down, either on the toilet or even in the tub or in the shower. I've seen in some cases grab bars that were needed in a kitchen area just because of how it was. Lowering kitchen counters, that would also go for persons in wheelchairs because the standard wheelchair, the counter is gonna be so high from you that it's gonna be difficult to cut things and to move things around, you know. Adding a ramp to the primary entrance, that also will be generally speaking for wheelchair-bound persons. Altering a walkway to remove steps. And installing a curb cut or a curb ramp. That's also to help either persons with wheelchairs, persons that can't lift their feet too high, because if the curb step is too high and you have someone who can't, that may be an issue. Installing disabled parking signs, lowering peepholes on doors. The installing disabled parking signs, we get a lot of these types of complaints as well. In some cases, the owners will say, you know, well, we have some disabled parking spots on this side of the parking lot, you know, and but when we get that complaint, generally speaking, we try to make it as convenient it is for the disabled person. So we will take into account, well, how far away is this? Are there any other parking spots that can be rezoned, if you want to call it that, into a disabled parking space that's closer for the person? Any questions on any of these? Okay, moving right along. Yes, some modifications may be considered accommodations, but either way, it is always best for the person to make the verbal and or written request. And if it does end up becoming either a modification or a accommodation, um, there's still normally enough information to show like, hey, owner, this person did make some type of legitimate request. Maybe they said, reasonable accommodation when they meant modification, but the request still was conveyed and attempted. All right, moving to the next one. More prohibited acts. This is 3604 F3B. This is the refusal to make reasonable accommodations in rules, policies, practices, services, when such may be necessary to afford a person an equal opportunity to use and enjoy. So that's normally, you see it when someone's asking for, when Kate earlier was talking about a no pet policy. Well, yeah, you can have a no pet policy, but if someone has a service animal, or if they have a therapy animal, or an emotional support animal, well, the rules for the pet policy do not cover that therapy animal, that emotional support animal, or therapy animal. So many of our complaints are due to issues with owners not fully understanding the Fair Housing Act when it comes to emotional support animals, or therapy animals, or service animals. Many times, like, for example, if a city has a ban on a particular breed, well, and then someone goes to rent somewhere and they tell them, well, I also have this emotional support animal that is this type of breed. Many times they'll be denied right then and there. If they contact our office, we advise them to ask the city for some type of waiver for that, for their specific animal, since the city has no knowledge on their specific animal, not just the breed, but the animal itself, before they go towards making a full complaint against the owner, because ultimately the owner is just following out the city's policies. So, most of the time, ESA requests are handled, without any issues. Most owners throughout America do understand how to treat persons with disabilities and their requests. It's just that sometimes being that it's difficult to understand, like, well, someone has a emotional support animal certification. Is that the same as an emotional support animal letter from a doctor? It can become confusing, the different terms. Moving on to the next one. Transferring a tenant from third floor to first floor. That is a type of reasonable accommodation we come across a lot, especially if someone who was not disabled before, but is disabled now, living on a third floor, and they can no longer go up the steps, let's say. So making a request to move units, that is totally a reasonable accommodation that is open for them. Accepting a service animal that exceeds weight restrictions. I know I am currently looking at an investigation in which the owner's weight capacity was 25 pounds, and the woman's dog, her emotional support animal, I should say, was 35 pounds. And ultimately, the woman had to leave the property because she would not give up her animal, and she's correct. It's unfortunate sometimes, especially with it's unfortunate that the idea that the pet rule not applying to a service animal is not generally known. But we'll move on. Allowing a tenant to pay when their check arrives instead of the first of the month. This is something I've seen before as well. Many times persons who are on Social Security disability will get their check on a particular time of the month, and it may not be aligned with when they can actually pay their rent. But if someone does, make a request of this nature, it's a reasonable accommodation. I know it doesn't sound like a reasonable accommodation. I've had to speak to many different landlords to explaining, not people who are in trouble, but just people who generally wanted to understand how the Fair Housing Act works. But, that is just one other way. So if you come across that, you might know how to assist somebody. The last one here is accepting an animal that is a restricted breed. That's what I was saying with, generally speaking, we will ask the person making the complaint to speak to the city clerk, or even the city council to make a request. Okay. Two-prong analysis for reasonable accommodations. Okay. Does the person seeking the accommodation have a disability that substantially limits one or more major life activities? So this is something that a property manager should think about. Does the person seeking the accommodation have a disability that substantially limits one or more major life activities? So, everyone's used to the stereotypical blind man with a seeing eye dog. It started becoming different when people started understanding, like, sometimes you just can't overtly see a person's disability like that. Especially when we started allowing motion support animals, like you may not see the person's disability. But that does not necessarily mean that the person is not disabled. So does the person seeking the accommodation have a disability that substantially limits one or more major life activities? Yes, you can think that. Let me see, the second one, will the accommodation eliminate one or more symptoms of a person's disability? So if I live in Kansas, I had someone ask once, can I ask my landlord to be able to smoke cannabis because it helps with my disability, my back condition? And in that case, it was like, it's not legal in your state. I apologize, but we can't do that because they were upset that their landlord would not let them do that practice. And in that particular case, it was like, yes, you're right. It may alleviate some of your disability issues, but it's still not aligned with what's legal and what is not. All right, I'm moving into the next one. Documentation of need. A housing provider may not ordinarily inquire as to the nature and severity of an individual's disability. However, in response to a request for reasonable modification or accommodation, a housing provider may request reliable disability-related information. And generally speaking, that is what we would call like an ESA letter, or some type of note from your doctor, or some people may refer to it as a doctor's prescription. It doesn't necessarily need to be a doctor. If we're talking about ESAs or motion support animals or service animals, it could be a psychologist, it could be a counselor, it could be a specialized type of social worker or a specialized type of medical nurse. Those are the ones, like, theoretically speaking, as far as ESA letters go, I've heard lawyers and other trainings that we've been to say that, anyone can give their account as to your perceived disability. However, trying to fight that in court, that you have a mother's note, is not enough. Maybe you should get a doctor's note. So it's totally acceptable for us when we understand that a homeowner, excuse me, that a property owner or a property manager requests some type of documentation, you know, just saying like, hey, you know, this person, in my opinion, should have a emotional support animal. In this case, they want a cat. Thank you very much. If you have any questions, please call me back. And generally speaking, you see the person's name and contact information. Like, that seems reasonable. But if, you know, the doctor gives them that and then they don't like the letter, they want more language, and then the doctor provides that, and then they don't like that one, and then they just become more picky. And then, like, let's say a month goes by of you've already had 4 or 5 letters go back and forth. Like, that's not reasonable. You already understand that a medical practitioner has given you enough information for you to reasonably understand that, you know, your potential tenant or tenant has this issue and has this need. Any questions for any of this so far, people? Okay, moving forward. This further goes on with the documenting the need, or like generally speaking, this is something we think that, like, let's say a property manager might use. Okay, so when the disability is not disputed and is not and need is not questioned, documentation is not justified. What that means is if you have a tenant who is, let's say, in a wheelchair and they ask for a reasonable accommodation that's related to their disability, that it's common knowledge that this person has a disability. It's common knowledge. So to require the person to provide more documentation that documents their disability and their need for said request is going a little bit too far. Or, you know, for example, let's say you have a blind person living in a unit and now they want a service animal. Like, this isn't something that the blind person should not have to get a lot of documentation for it. In fact, they would probably not need any documentation for a request of that nature. All right, second point here is when the disability is not disputed, but the need is questioned. So documentation related to benefit or need is justified. So, whoa, I didn't want that. So when the disability is not disputed, but the need is questioned. I can't remember or recall a complaint that I've had that's been like this. Kate, have you had any cases that have been like that?
Yes. So let me think of an example. Well, so a lot of times these are like the emotional support animal cases. So in the previous example, it was obvious the person was blind. It was obvious they would benefit from a service animal. The service provider might not be questioning the disability of the person needing emotional support from the animal, but they might be saying, I don't understand how this animal is how it is gonna assist you with your disability. I need some information about how the need for the animal is related to your disability. And then they might get a doctor's note that better explains, well, they don't have to disclose their disability. They don't have to say, for example, I have anxiety. You know, they might just say, I have a disability related condition and the dog assists in calming me down. And so maybe that's a better example for the not a parent, because anxiety is not apparent like being blind is. Maybe it would be, or, you know, a dog that assists with your seizures. They notify you before your seizure, a service dog. You might not be clear on that, but once they explain to you the need for the dog, you're like, I know with a blind person, the dog is leading you around, but I don't understand what this dog is doing for you. And once it's explained, well, I have seizures and this dog alerts me before I have a seizure so I can get in a safe place. Then that's explaining to you the need and justifying the need, and then that should be sufficient.
Thank you, ma'am. Thank you. All right, so the last part of this documenting need is when both the disability and need are questioned, documentation of both is justified, its acquisition should be limited to that specifically needed and kept as private as possible. That's typically what occurs when you have a brand new tenant applying to go into a possible property because they have no history of the person, and they're just verifying to ensure that the person can get the requested accommodation. Let's go to the next one. Let's see. 3604 F3C, failure to design and construct an accessible property. Applies to all properties constructed on or after March 13th, 1991. All right, so apparently this year has been my year in learning design and construction complaints. So like I was investigating earlier this year before the COVID locked us all down, a brand new subject property that was supposed to have 70 units. But the garbage disposal area, you know, it was a humongous just dumpster, garbage dumpster. But if you were in a wheelchair or if you couldn't sashay into the space that they had for you to sashay into to throw out your garbage, I'm guessing they've never had anyone in a wheelchair before living in their units, because we made them, you know, change the orientation of how they had this whole setup, because and we also made them change the type of garbage dumpster that they were using, because there would have been no rational way that a person in a wheelchair or a person, like let's say using a cane, could have let go of that the support from that cane to throw their garbage into this area in the way that they had it. Okay, so 7 basic requirements. Requirement 1, accessible entrances and accessible routes. So these are requirements that all structures in America as of 1991 have to have, right? Accessible and usable public and common use areas. So if you're gonna go into a public restroom, hear what I say, a public restroom, the doorknob should not be a round doorknob, because like, let's say if you have someone that has issues with grabbing structures like that, or in some cases an amputee, they may not be able to grab a round doorknob. So you'll see the other doorknobs that are actually like, you know, they're little hooks, or they kind of point out, you know, it's a straight line and you push it down, it'll be something to that effect. Usable doors, accessible route into and through the covered unit. Light switches, outlets, thermometers, and other environmental controls. Reinforced walls for grab bars, usable kitchens and bathrooms. It's interesting that light switches and where they're at, how far off the ground they are, those are other types of complaints I've also seen in the past, right? Moving on to the next one. USC 3605 covers residential real estate related transactions, including making or purchasing loans or providing other financial assistance, selling, brokering, or appraising residential real estate property. So the example they have over here is, so, whoa, come back. There you go. Realtor owned multiple homes that were sold on a contract for deed basis. It was later found that the buyers were evicted for missing payments when they had not. All of the buyers were Hispanic who did not speak English. Um, so generally speaking, when I tell somebody that I'm an investigator for the Office of Fair Housing, I explain that we not only can look into transactions that occurred between a typical renter and lease, someone who wants to rent the space, but those transactions can also affect the insurance companies, the mortgage companies, third-party contracts. It's something that doesn't just stay at a tenant and a landlord, because housing is a large field, and the Fair Housing Act and ADA and other issues like that we deal with don't just stay at the foot of a landlord-tenant relationship. In this case, the example they're talking about, in which a owner ended up kicking out some possible tenants that wanted to possibly buy the home, when it was done incorrectly, it would be the type of thing that we would collect data, we'd interview everyone, and we would make our determinations based on the evidence. But looking at an example like that, I would have to say, like, no, that doesn't sound right. Because you can't do that.
Tito, I have a few more examples for that. Oh, maybe this is going to get to it. Never mind. Do the example.
Roger that. Facts. National Bank offers a refinance program for its mortgages. Complainant, who is a female on maternity leave, is told she cannot apply for the program until she returns to work. Question, is this a violation of the act? Yes, it is. It actually was something that happened a few years ago with an unnamed bank, but I'm sure if you can search for it, in which the only reason we find out about it was because one of its employees, who was pregnant and I believe looking for a home with her husband, the bank would not give her a mortgage. They wanted, because the crazy idea is like, well, when you have your kid, we don't know if you might return to work or not. So, your income may change. So we want to, out of safety concerns, we want to just hold on this possible mortgage deal. Like, no, you can't do that. So it was interesting to us that the bank applied the same policy against its own people, and it was one of its people and other various members of that organization that ended up making complaints against that organization. Hey, you got any other examples for that?
Yeah, one more. So the one Tito just talked about, again, it's familial status, because remember we said pregnancy is covered under that. The other one we've seen is after the 2008 housing bubble bust, and there was a lot of foreclosures. So banks were owning a lot of properties. There was a Fair Housing Act case where banks were maintaining their bank-owned properties better in white areas. They were keeping up with the mowing of the lawn and, any maintenance issues that occurred while it was vacant. And then in communities of color, the same bank was not maintaining the houses. They were letting the yards get way overgrown. If, the gutter was falling down, they weren't fixing it. And it was shown race-based discrimination against a mortgage bank for the maintenance of the properties. So there's just another example.
Cool. This is USC 3606, unlawful to deny access to or membership or participation in MLS, real estate brokers organization or other service organization or facility related to the business of selling or renting dwellings. Also, along with USC 3606, unlawful to discriminate against him in the terms or conditions. I think that's wrong there. But unlawful to discriminate against in the terms of conditions of such access, membership, or participation. So that would be let's say a realtor, real estate brokerage group that, it's mostly one race or one religious affiliation. You can't do that. We just not how it works anymore. Next one, 36, USC 3617. Unlawful to coerce, intimidate, threaten, or interfere with any person in the exercise or enjoyment, or having exercised or enjoyed, or having aided or encouraged another in the exercise or enjoyment of any rights. So the example they have here is property manager evicted tenant for stating she thought she was being discriminated against. So many times what happens when someone makes a complaint with us is that we have to officially send out notification letters to all parties that there was an official HUD complaint, discrimination complaint put against the property owner or the property management company or something to that effect. And in some cases, the owners will move towards trying to evict the person that made the complaint. And if they go towards something of that nature, that ends up being another violation of the Fair Housing Act, because ultimately the person is threatening you to stop your complaint that you filed with the federal government. And the federal government is not going to have that. So if any of you folks ever have to make any type of complaints with our office, but you're afraid, or the person you're dealing with is afraid that it may get worse for them, at the very least, we do have additional laws that prohibit this and actually bring the actions of the owners or the property managers into question if they did indeed intimidate you or threaten you or interfere with your ability to have a safe home, to live in a safe home.
And Tito, so I just wanted to add, this would also protect like a property manager. Let's say you're a property manager and a tenant comes to you and says the maintenance man has been sexually harassing me, and sexual harassment is covered under the act by sex protections. And as a property manager, you said you should file a fair housing complaint. If you think you're being sexually harassed, you should file a fair housing complaint. And the regional manager comes down on the property manager and says, why are you telling them to file a complaint on us? Now I'm going to fire you. That would be covered under this too, because you're informing them of their fair housing rights, and then you're being retaliated against for helping someone, so aiding or encouraging another in exercising the enjoyment of their rights. So this would also protect any housing providers that are, providing that assistance or referral from retaliation.
Thank you, Kate. Thank you. That very correct. All right. Next. Pop quiz, everybody. Okay, facts. Fair Housing Group filed discrimination complaint against property and did a press release. The attorney for the respondent, meaning the other side, filed a lawsuit based on various tort actions. So the sounds like the property owner had an attorney that filed some other civil lawsuit actions against the Fair Housing Group that filed a discrimination complaint and did a press release. Okay. Did the attorney's decision to file the tort action violate the Fair Housing Act? Well, as Kate was saying earlier, I have to answer it in a very lawyerly way. It depends. It depends on what exactly the history was on the tort or civil actions that the attorney went towards. It depends on what they are, not just the history, but what they are as well. Because if you have something that, goes back as far as history, that's longer than the actual discrimination time frame, then, that makes sense. But if, mysteriously, you've never had issues with this at all, you've never written the person up for them at all, But mysteriously now you go towards some type of legal actions like that. It may be construed by our office to be a violation of the Fair Housing Act. So it really does depend. Okay, next slide. USC 3631. Whoever, whether or not acting under color of law means that it's not lawful at all. By force or threat, willfully injures, intimidates, interferes with, or attempts to injure, intimidate, or interfere with their rights. Homeowner reported neighbor for harassment under the act. Neighbor's brother showed up and made threats that included physical violence and or death. Case was referred to US DOJ. That's the example that they're giving there. So like, I know I've been an investigator on a few different cases in which someone was making complaints to a property manager, and in some crazy way, the property manager had influence over one of the tenants, and one of the tenants got into a fight with the person who made the complaint. And then after that, a friend of the other tenant that made fights. Like I've seen some insane things that when you look at it, you're just like, well, come on, people, we're all just trying to live together and be happy, man. What's the matter? Like, you know, either way, folks, if you ever come across a housing situation that you're involved in, you need advice for a situation you're in, someone else you may be in, we have an office at Kansas City, Kansas. We have various people that can answer any questions. You don't have to necessarily call us up to file a complaint. You could always call us up just to ask questions or to explain your situation and see if it would be best to go towards filing a complaint. I know that, like, you know, the slide that I have up has a lot of resources and things like that. But ultimately, you know, you have a local Office of Fair Housing office that can answer your questions. Normally speaking, if it wasn't during these times, we would have people come to the office and ask questions or even make complaints at the office. So if you ever get into a situation in which you have questions, or you can even we're on the internet, you know, if you're a property manager and or owner, you have any questions concerning moisture support animals or service animals or any policies, you know, don't worry. We're not gonna like, figure out your phone number and where you live at and say, haha, we got this person admonished something that they were doing. It's not gonna be like that at all. We just want to make sure that if, you know, that tenant relations are going well in America. And if you ever need any guidance with steering, please contact our office. I don't think any of these slides have our information, but I'll give my information, my email, my phone numbers as well.
Tito, we do have one question in the chat box that I'll read.
Ooh,
It's about assistance animals. So the example they're talking about is a healthy tenant whose dog is over the weight limit, but the prior executive director admitted the dog because she brought in a doctor's note. And at a social gathering, this person heard this tenant say, the tenant was asked, how did you get that dog, that big old dog in that was over the weight limits? And the tenant laughed and said, oh, I just asked my doctor for a doctor's note and he wrote it. And so I think this person who's asking the question is the new executive director, or the other person is anyway. So now the tenant thinks she'll be asked to leave because she says, does that fake letter override what I actually know? And so one of my things that I'm thinking about is, if we were doing an investigation on this, we do defer to the doctor. And lots of doctors do write, you know, it's like the same if you go and say, like, I'm having trouble sleeping, can I try some sleep medicine? You know, they say, I'm having trouble this, what about an assistance animal? So we always defer to the doctor. I think we need more evidence that this is a fake letter, right? Because this is a conversation we had in passing. So we could interview you, we could interview other people that had heard the conversation to document that. And if we got a lot of people saying, oh yeah, we've heard her talking all over the place that she's not disabled and the doctor just did this for her, that might be enough evidence. But if we can't get people to go on the record that they heard that, the doctor's letter will probably take precedence. What do you think, Tito?
I think ultimately, due to the doctor's certification, what she said in a conversation, that could be a lie. You know, like that doesn't necessarily mean that it's the truth or a lie for that matter. But it would end up we're going to end up contacting the doctor, and then we're going to go towards asking a lot of questions about the specifics of the need. And it'll be in that realm that through our questions, we're going to see if there was a need, and if the letter and the granted accommodation was correct. You know, because even if she went around telling everybody that, you know, I got it for this other reason, but it ultimately would be like when we went back and spoke to the doctor, this is what the doctor said, and the doctor's been seeing her for, you know, it'd be different if it was like, so this was the first and only time you ever saw this patient and you gave them this note. Like that would be one thing versus you've been seeing this patient for 3 years.
Right.
So I could see that.
Yeah, so that's a tricky one. We have a few more questions coming in. I'm going to go to these ones that are also about service animals really quickly. Someone's saying, what about certificates you can buy online for service animals? I refer you guys to the link that I sent you for that 2020 assistance animal guidance. If you Google like HUD January 2020 assistance animals, HUD has issued guidance and it talks about these online certificates. So I'm sorry, online certificates are different. First of all, an assistance animal, an emotional support animal doesn't need any sort of certificate to be valid.
Mm-hmm.
An online doctor, which is how I originally read your question, is fine. And we all know in the pandemic, we're moving to more remote support. Again, we'd interview the doctor, you know, and see if the doctor knows enough to talk about what the disability is and the disability related need for the dog. But so an online certificate that you just purchase offline is not enough. It's not required by the per the Fair Housing Act to permit an assistance animal, and rather we'd be looking for some sort of documentation from someone with an intimate knowledge of the person's disability and the need for the dog. It doesn't have to be a doctor. It could be a psychologist or a nurse or a social worker. And so then another question we have is about a pool table with no child under the age of 15 can play without an adult. Is this like the pool? Yes, it is. So that is a rule that you're applying to families with children that aren't applied to families without children that might be an issue. Because I don't see, you know, I'm not sure I see a legitimate business need for that restriction. And so the last question I'm seeing, unless I missed something, is about the doctor's note. So can I verify with the doctor if ever needed? And I would say you could probably verify, did you produce this note? But you want to be careful about asking too many intrusive questions into a person's disability, because you're not allowed to inquire into the nature or severity of a person's disability. You would only want to say, did you produce this note, and are you recommending an assistance animal?
I agree.
I know we're right at time. I don't see any more questions coming in. I hope you all found this informative. And we can pop our emails in the chat box for you if you guys have any questions in the future or that we didn't get to. Thanks, everyone.
All right, everybody. Thank you guys so much. That was wonderful. I'm going to go ahead and throw up the game code for those of you who are